Back to that breaking news from the Securities and Exchange Commission. The SEC may decide to publicly rebuke Lehman Brothers and its former executives, but not sue them for actions that led to the biggest bankruptcy in U.S. history. Our reporter Joshua Gallu joins us from our Washington bureau. Josh, bottom line is this the government saying they were unable to find proof of fraud?
The bottom line is that's what it would say. To some extent, this means that they weren't able to find it. On the other hand, they're able to find things that they find questionable, but may not be supported in a lawsuit. It's very different to criticize than it is to actually win a case in court, and that's the hurdle they're running up against.
So this public rebuke, it's very rare. Clearly, SEC feels they need to do something, but is there any kind of consequence here? I mean, specifically, what are we talking about? Is this the Repo 105 transactions and some of those issues?
The Repo 105 transactions are at the center of the inquiry. Definitely that's what the SEC has been concerned about. The question is whether or not they actually were a technical violation of the law, and there's a broad consensus that they weren't. If they don't actually violate the law, it really ties the SEC's hands in terms of what kind of case it can bring. This kind of report offers them the opportunity to get out there in the public, say that they found the accounting practices questionable, and to warn people not to do it again in the future. It's basically a way for them to respond to a lot of public and political pressure about not having been aggressive enough on financial crisis cases without actually running the risk of losing a case in court.
Josh, I know I'm asking you to connect the dots a little bit here, but to try to make history relevant a little bit more to some of the ongoing issues. Any implication for Goldman Sachs and some of the autopsies that they're undergoing right now?
That's very difficult to say. I think that these things are taken on a case-by-case basis. I would be awfully surprised if this stretched into that realm, but it appears that this kind of tool, using these reports as opposed to bringing cases in court, it's something that the SEC is looking into. They've only done this 6 times in the past decade, but 2 of those times were last year. They issued one report against J.P. Morgan, which involved pay-to-play issues. They issued another one against Moody's saying they didn't bring a case because of jurisdictional reasons. It's clearly a tool that they're trying to get a little bit more mileage out of when they're faced with a lot of pressure on these cases, but don't necessarily have the legal grounds to bring a case.
All right, Josh, thanks for coming on and explaining that important development to us. I appreciate it.